The battle against patent trolls is the topic of my conversation today with Michael Sandonato. He is a partner in the law firm of Venable LLP. Michael, welcome.
Thank you, Robert. Good to be here.
So, Michael, what is the Advancing America's Interest Act?
Robert, the Advancing America's Interest Act is a bill that was proposed by Representative Del Bene from the 1st District in Washington State. And it's all about trying to limit access to the International Trade Commission to those entities that the bill views as having a genuine domestic industry. And it's probably worthwhile to step back here and talk about what a domestic industry is in the context of the ITC, in the context of the International Trade Commission. The International Trade Commission is of course, a quasi-judicial body that sits in Washington and has the ability to issue something called an exclusion order in cases of patent infringement and other unfair acts. That is to say, if the International Trade Commission, the ITC, identifies certain products being imported into the United States as infringing, and the patent owner brings an investigation and can prove that they're infringing, then the ITC can issue an order that directs U.S. Customs and Border Protection to stop those infringing products at the border. And that's necessary to do if you want Customs to stop products that infringe a patent. Customs will not get involved without an order from the ITC. And it's different than trademarks, for example, where Customs will on their own, without any kind of ITC order, enforce trademarks against, for example, counterfeit patents.
So that sounds like an important role. Sounds like actually it could be a good thing to actually protect legitimate patent owners. And yet here we have these so-called patent trolls taking advantage of that. In what way are they doing that?
Well, of course, whether you view patent non-practicing entities, what I'll call non-practicing entities or patent trolls, as taking advantage of the system sort of depends on what side of the aisle you're on. And I'm not talking about the political aisle. I'm just talking about how you feel about the role of patents in the United States. But certainly the way that some perceive non-practicing entities as taking advantage of the system is as follows. In the ITC, as the rules exist now, in order to gain access as a patent owner, you need to prove that you have what's called a domestic industry that warrants protection. There's a number of ways to prove that you have a domestic industry, but I would say the most classic way, for example, is to show that you manufacture the patented product in the United States. And that's the money that you put into that and the resources that you put into that and the employees that you have doing that are the domestic industry that's worth protecting. For a non-practicing entity being an entity that owns a patent but doesn't practice under it, they of course cannot point to any manufacturing activities in the United States or any other activities related to their products in the United States. And so what they would classically do under the current law is point to two things. Number one, they would point to their own expenditures and efforts in licensing their patents to others. And for non-practicing entities that have licensed their patents to others, they might try to point to the activities, for example, the manufacturing activities of their licensees. And under certain circumstances, if the expenditures are enough, they can do that and they can successfully gain access to the ITC by pointing to their own licensing activities or by pointing to the activities of their licensees. This new bill would dramatically limit their ability to do that.
Okay, but I'm trying to understand this. Like, for instance, there's a patent topic that's come up in the last few months. The regents of the University of California are going before the ITC to try to stop the sale of a type of non-filament or light bulb that was developed by researchers at the University of California. The light bulb is not manufactured here in the United States, but you could see where the UC would be able to assert legitimate rights over that patent nonetheless. That seems like a legitimate issue. On the other hand, do you not, in fact, have these entities that are called patent trolls that all they do is own the patent? They don't manufacture, they don't distribute. How can we distinguish between those and identify those as the parties that are in fact kind of gaming the system?
Well, the way this bill would do that is as follows. Going back again to those two touchstones that a non-practicing entity has, the ability to point to its own licensing activities and the ability to point to the activities of its licensees. Under this bill, the patent owner could only do that if it can establish that the licensing led to the adoption and development of articles that incorporate the patent. And that's an important distinction from the way that the law is written now, because there's no requirement now that the patentee needs to show that. Right now, all the patentee needs to show is, for example, that it licensed its patent to Company X, and Company X is indeed making a product that's covered by the patent. Mm-hmm. The history of how that product was developed is not important. And in the most classic case of a non-practicing entity, when a non-practicing entity licenses a patent, it's typically licensing the patent to a company that already built and made the product, perhaps without even knowing about its patent. But
I see.
If the product that the company is making is covered by the patent, that is enough. Under the new bill, that would not be enough. And again, the patent owner would need to establish that the licensing actually led to the adoption and development of a patented product.
Just to be clear, these entities we're talking about could theoretically take a complaint before the ITC without even consulting the actual original manufacturer of the product that is patented, right?
So in the most typical case now, when an NPE brings a investigation before the International Trade Commission, they will not consult, for example, their licensees. Mm-hmm. If a non-practicing entity, again, licensed Company X, they would typically file a complaint in the ITC, point to perhaps the manufacturing activities of its licensees, but not join or consult its licensee. After filing the lawsuit, the patent owner would then subpoena documents and records and perhaps even testimony from its licensee to gain evidence to prove its domestic industry case.
I see.
That's something else that cannot happen under this new bill. Under this new bill, it becomes a necessity for the patent owner to join the licensee as a co-complainant.
Do you believe that this issue takes on additional urgency in the time of pandemic?
So it's certainly been argued that in the time of pandemic, the supply chain issues are more important than ever. And so the supply chain has, in some varying degrees, become compromised. And I do think that one of the motivations behind this bill is the concern about the supply chain, the concern that, let's say, a inappropriately issued exclusion order could have negative impacts on the supply chain. And there's actually an additional wrinkle to this bill that I think is trying to address that. And that's a layer of this bill that requires that in order to issue the exclusion order, the ITC affirmatively see that it would benefit the public interest. And that sort of reverses the burden of proof, if you will. Under the current law, the ITC should not issue an exclusion order, whether it's an NPE or a practicing entity who owns the patent. The ITC should not issue an exclusion order if it's against the public interest. This new
ITC has a public interest obligation. That's kind of its guiding light, so to speak, correct?
There is a public interest obligation, but again, and currently it's framed as don't issue an exclusion order if doing so would be against the public interest.
Here again, public interest, depending on what side of the aisle you're on, the definition of that can take so many forms. All right, it's a bipartisan bill. It sounds great, and yet how much time do we have left in this Congress? We have a presidential election a month from now. Does it have any chance of passage in this Congress?
I certainly don't see this bill passing in this Congress. It's my understanding that it's just a House bill right now. I haven't really heard a lot about it in terms of gaining momentum since it issued, I think, in the middle of August. So I think in terms of this Congress, the chances are virtually nil. I think that the way to think about this bill is that it's starting a conversation. And I do think that that conversation will continue into 2021 and beyond, and that we ultimately may see some legislative changes with respect to the ITC. But I don't think that this bill in its current form is going to be passing anytime soon.
Perhaps a conversation that is long overdue, but we can
Many certainly feel that way.
Yeah, so HR 8037 going nowhere this year, but certainly possible it'll pop up again in the next Congress and maybe some action will really be taken. But Michael Sandonato of Venable LLP, thank you so much for talking to us about this bill. Very interesting, and as you say, beginning of a conversation, and I really appreciate your elucidating the issue for us. Thanks very much for being with us today.
Thank you, Robert. It was my pleasure. Have a great day.